This is East Coast Radio.
We speak to Edward Abraham, Senior Litigation Attorney and Partner at Pather Attorneys, voted Best Law Firm in the Best of Durban Readers' Choice Awards in 2024 and 2025, to unpack the legal side of this landmark ruling. We've been talking about a landmark case that's raising serious questions about social media, responsibility and the law. A jury in Los Angeles has handed down a landmark ruling finding that social media platforms were intentionally designed in a way that contributed to a young woman's addiction and ultimately harmed her mental health.
So the woman in question, who is now 20, was awarded millions of dollars in damages, and this case could have ripple effects for hundreds of similar cases still to come.
Now, to help us unpack the legal side of it all, we're joined by Edward Abraham, Senior Litigation Attorney and Partner at Pather Attorneys.
Edward, good morning.
Good morning.
Thank you so much for joining us. Please, could you help us understand what this ruling really means?
Yeah, sure. So good morning to all the listeners. So obviously, there are two major legal developments in the United States, as you've mentioned, involving the Meta platforms and YouTube, that are really starting to reshape how the law views social media. So the first landmark case, which you mentioned in Los Angeles, involved a young woman who began using Instagram and YouTube as a child, and she told the court that she had become addicted to these platforms and suffered serious mental health harm, including depression, anxiety, and self-harm. Now, traditionally, companies in the U.S. rely upon a powerful legal protection in the United States called Section 230 of the Communications Decency Act. In simple terms, there's social media platforms are obviously not legally responsible for content that is posted by users. But in this case, obviously, the argument was a little bit different. The claim was not about harmful posts. It was about the actual design of the platforms themselves. And in this case, the plaintiff had argued that features like the infinite scroll, autoplay, and the algorithm-driven recommendations were actually intentionally built to keep users engaged, and that this design was, in fact, defective and dangerous, especially for minors. So the claim was framed as a product liability and a negligence claim. So the court had to consider whether there was a duty of care and whether that duty of care was breached and whether the design of these platforms caused harm. There was also the failure to warn argument. Now, one of the most difficult issues in this case was causation, and the defense had argued in this case that mental health has many causes of harm. And the court, however, accepted that the platform design was the substantial contributing factor, which is enough in U.S. law, but I must say that in South African law and our court would apply a stricter approach to this aspect of causation. So a jury in Los Angeles obviously agreed, and they found the both companies negligent. They awarded about $6 million, roughly 4.2 against Meta and 1.8 million against YouTube. So crucially, the court drew this distinction between content, which is protected, as I mentioned, under Section 230 in the US, and platform design, which is not clearly protected. Now, I must also tell you that what was interesting is that this verdict came one day after a separate case in New Mexico in the US, where $375 million was awarded in a case involving a failure to protect a minor from harmful content and interaction. Now, lawyers in the United States are already comparing these cases to the big tobacco litigation that came in the past, where the tobacco companies were held liable for these harmful tobacco products they produced despite knowing the risk and failing to warn the public. And those cases, we know, ultimately led to massive payouts and sweeping regulations of tobacco and cigarettes in the world. So from a legal perspective, this is a test case in the United States. And there are already thousands of these similar cases waiting in the U.S. So if the appeal fails from Meta and YouTube, it could open the floodgates to many more lawsuits and force changes in how these platforms are designed. Now, from a South African perspective, I think two issues arise. One is jurisdiction and liability, because I suppose the question would come is, can me as a South African, if I suffer the same harm, can I sue Meta and Facebook at the same time? So in our court, on the question of jurisdictions, our court can hear a matter if there's a sufficient connection to South Africa. This includes where the harm is suffered. So even if the company is foreign, our law allows for what's called founding or conforming jurisdiction. This includes attaching assets of that company if they need.
Yeah, man, Danny and Zisto in for Darren, Carmen and Sky. We had a conversation earlier on about how addictive social media is. And we had a gentleman, Edward Abraham, who is a senior litigation attorney and partner at Pather Attorneys, just telling us how this case that happened in the US, where a 20-year-old sued sued Meta for millions of dollars, and how it could be brought back to home. What does that mean for us as South Africans? Because we know that people are addicted to the social media.
From a South African perspective, two issues arise: jurisdiction and liability. On the question of jurisdiction, now, our courts can hear a matter if there's sufficient connection to South Africa. That includes where the harm is suffered. But you would have to found jurisdiction. On the question of liability, we do not have the exact equivalent to Section 230, but under the Electronic Communications and Transactions Act, platforms have a limited section for third-party content, provided they act when they are notified. A claim here would be based on the common law of delict. The claimant must prove wrongfulness, fault, causation, and harm. That remains a high threshold, especially in cases involving mental health, and our courts would require a clear and direct causal link, not just a contributing factor as accepted in the United States. For children, laws like the Children's Act and Protection of Personal Information Act strengthen the arguments around the duty of care. But this is bigger than just one case. What happens in the United States will have global consequences. If courts there force changes on how platforms are designed or regulated, those changes will flow across the entire global systems of Meta and YouTube. That means the way these apps function, the features they offer, and how they engage users could change worldwide, including here in South Africa. And alongside that, I think governments around the world are already responding to these aspects. In Australia, there are moves to restrict access for children under the age of 16. In Europe and United Kingdom, regulators are targeting addictive design features. And in China, for example, platforms like Facebook and Instagram are restricted and largely inaccessible, with tight state control over digital platforms. So this is not just a United States case. Courts and governments around the world are asking one question: are these platforms simply tools, or are they products designed in a way that can cause harm? And for us in South Africa, I believe it's not a question of if change is coming, but when it reaches us.
You know when someone speaks and you go, yo, I trust that guy.
Yeah.
That's that guy.
100%.
Hey, that was Edward Abraham, senior litigation attorney and partner at Puther & Puther Attorneys. Thank you so much for your insight there.
Yeah, eh?
This is East Coast Radio.